Hi, everyone, and welcome to Raw Law. This is Arkady Frekhtman. I'm a New York City personal injury trial attorney. And today we're doing one of our lives where you could join us and you could ask questions. And we're here and we could answer your question live. We could discuss your case. So welcome. So I didn't actually schedule this one in advance because I had court today and I was in a deposition. So I wasn't sure if I was going to be able to do it or not. So we kind of did this one last minute. So if you are joining and if you're able to join live, just ask us a question. But if not, what I'll do is I'll jump into our channel and maybe answer some questions from the channel as we get started, just to get everything started. Maybe I'll do a few questions from the channel. So let me jump into the channel here. If I go back to the community tab, let's see what questions we have here. Here's a question just from 28 minutes ago from a Jasbeen Dean. And the question is, what would be your opinion if the verdict is $100,000, $40,000 lawyer fees, $45,000 medical bills, and $15,000 is for the plaintiff? Please explain what the plaintiff should do. Just curious to know. Yeah, so it sounds like maybe this is a California case, because I know in California they do have a 40% attorney's fee. So that takes away, right? So you take away $40,000 out of 100. Now you're left with 60, and he's got 45 in medical bills he's got to pay back. So I guess, yeah, that's unfortunate. You could only, even though you settle for the policy and you're supposed to get like $100,000, which sounds like a lot of money, but you're only getting like 15,000, right? Which is very little. So that's just an unfortunate situation. I would ask the lawyer if they could reduce their fee. I would also ask if the lawyer can negotiate the medical bills down, because that's a lien, right? So maybe they could, instead of 45, they can take 20, and then you get more money. That's really the best you can do. I mean, it's always tough when you have a small amount of money and it's not much you can do with it. Unfortunately, it's always a tough situation, because it's a small amount of money and everybody wants a piece. It's basically like splitting up a pie, right? But the pie is really small, so everybody wants a little piece. Everyone just gets a taste instead of an actual piece. Yeah, so unfortunately, that's just what it is. And then the higher says, how does the jury come up with a number for indemnity, or to indemnity? So yeah, I'm not sure what you mean by that, for indemnity. Do you mean like when one insurance company is supposed to indemnify another one? That just means to like defend, right? To indemnify, like for example, if you're suing, let's say, a landlord, and then you have a case against the landlord, but they have a lease, so then the tenant has to indemnify them. So the landlord, is just not responsible. Like they could be responsible by law, because it's a non-delegable duty, meaning they can't pass the buck to anyone else. So the law will say, hey, you're the landlord, you had, let's say, a hole, you're responsible for this hole, but they have a contract with their tenant, because they're like, say, in Florida, they're retired, they don't want to have anything to do with the building. And so the tenant agrees to indemnify them. So whatever the landlord has to pay, like $1 million, the tenant will pay that. That's my understanding of it. But the jury doesn't really come up with that. That's more like a contractual thing. Oh, he says compensate, not indemnify. Oh, okay, compensate. So you're asking, how does the jury come up with a number to compensate? Well, it's based on the trial. So the jury watches the trial. First, you pick the jury. That's the very first step. So when you're doing the jury selection, a good plaintiff's attorney will actually ask them if the law and the evidence comes out. You're going to hear the law and the evidence. So you tell them how the trial works. You basically tell them, first, you're going to have opening statements. Someone's going to come up and tell you what the evidence will show. Then you're going to hear from witnesses. It could be the plaintiff, the injured person, doctors. So listen to the witnesses. And then you're also going to review medical records. We're going to have like slides up and medical records and information. So all that's going to happen. And then at the end of everything, when you match up the law and the evidence, our belief is that a verdict will be justified for many millions of dollars. And, how do you feel about that? And see what they say. Some jurors might say, you know what, I'm okay with that. if that's what it's going to be, I'm okay with allowing for many millions of dollars. Other people would say, no, I heard about these lawsuits. I don't like that. I don't think that anyone should get more than $1 million, no matter what. So, right. So then you get those people off your jury and you keep the ones that are more favorable, or the ones that at least could be fair, could give each side a fair shake. So you start in jury selection, right? Then during the trial, they hear the evidence, they hear the doctors testifying, they hear, everything basically. They hear the client, they hear the witnesses. Like you have community witnesses, so you'll have like friends, coworkers, whoever you have. It's kind of like, imagine you're putting on a play, right? Who are you going to call? So it's like the play of your life, right? Because it's your life has been changed. So you're putting on all these people. So however number of witnesses you're going to have, maybe 10, like economist, a doctor, a few doctors, life care planner, friends, family, coworkers, and then they get a sense. And then at the end of the case, both lawyers will say what they recommend. So for example, I would say, okay, I recommend $1 million. The defense lawyer will say, oh, this isn't serious. I recommend 20,000. And then ultimately it's up to the jury. So they go back into the jury room. They can call for anything that's been admitted into evidence. They can bring that back into the jury room because it's actual evidence. They can look at it, like medical records, slides. Some things are more like demonstrative. They can't bring that back, but they've seen it. And then they all have to come to a decision together as a group. And that's how they come up with the number. So they could actually allow for more than the plaintiff asks for. That's allowed. So, there's not really any specific formula. But that's a good question, how they come up with a number. Absolutely. Leonardo says, hello, hi, how are you? Thank you for being here. Leonardo's always here. Paul is here. If your case goes to a jury, is it really worth it when it's so expensive once you pay everyone their share? What would make a case worth going to a jury? Well, yeah, no, it's worth it. I mean, you're not really paying, what do you mean everyone their share? I'm not sure what you mean by that, but it's not really expensive. I mean, it is expensive in the sense that you have to prepare the case, but you're going to get a completely different number, right, by going to a jury. And you're also going to scare the other side. So there's like two things, right? By preparing the case to go to a jury, you're showing them that you mean business, that you're not playing around, that you're willing to go the distance. And then, as you're there in front of the jury and you start, then the other side sees, wait a minute, this guy's not playing games. They're ready. They're going to all the way. They're going to get a verdict. So then they start making the offer go up. So you could always settle it during trial, but you get completely different numbers. And I'll give you an example. Actually, next week, I'm supposed to go to court on a hearing. And it was a case where another lawyer had it before me, and the lawyer had like 100-something thousand offer, and he was telling the client, hey, take this 100,000 something offer. And the client was like, no, I don't want it. Then the lawyer says, come into my office, come into my office. And then the client comes into the lawyer's office, and he again tries to like strong arm the client to take this $100,000 offer. The client's like, no, I don't want this. But anyway, then the lawyer's like, oh, that's a lot of money, blah, 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 blah. And then basically the lawyer, after that happened, the lawyer like kind of stopped doing anything on the case. Yeah, I think it was like 190,000 or something like that. That was the top that they got. And then after that, 2 years went by, and the client sees like, he's not calling me back, nothing's happening, because the lawyer just, in his own mind, he thought like, oh, that's a good offer. Let's settle it for like 190. And then, and then the guy switched over. He came over to me. We prepped it. And then we ended up, we did a lot. Like now that guy, the first lawyer, he spent like $600 on the case. He did a few depositions, he did some stuff, but he spent like a few $100. We spent like 50,000 on the case because we did like animations, accident reconstructions. We hired economists, doctors, but we were ready to go to trial now. And during jury selection, we ended up settling that case for 2.2 million, right? So he didn't even have 200, he had like 190, and we got 2.2. So like, what is that? 10 times, more than 10 times. So you can get a lot more, but you have to be willing to go for it. I mean, we did a lot of work on the case, and we got a good result, and he was really happy with it. But that just shows you that it could be done. It just has to be worked up. But yeah, going to a jury, I think is like, that's like really your only real, that's the Seventh Amendment. That's a trial. That's civil justice. That's your only real shot at justice. Because what else are you going to do? The insurance companies, they could just be cheap. If they choose to be cheap, right? What are you going to do? That's the only option, right? We don't have eye for an eye. We're not going to go. What else could we do? That's our only option. We go to trial, we get verdicts, and then we try to enforce these, verdicts. And that's how the insurance companies judge the real trial lawyers from the guys that are just like, pushing paper or whatever. So yeah, I think that's the way to make the money. That's the way to do it. It doesn't really get more expensive. I think it's definitely worth it. I prepare every case for trial. Not every case is going to go to trial, right? 95% of cases settle, and that's because they see that if they don't settle, you're going to get a verdict against them, so they settle. But you know what I mean? It's a fine balance. You can't just rely on them always settling, because what if they don't settle? Then you have to take them to trial, right? And get the jury to hit them with a big number. Then they get scared again. Then they start settling again. It's actually very true. Like at one point we were doing really well with mediation. This was like maybe, I forget when exactly. It might have been like 2014, 2015, and then we were doing so well with mediation. We kept going to mediation. Oh, we did a mediation, 3 million. We did another mediation, 600,000. We did another mediation, 1.5 million. And we were doing so well with mediation. We were like, oh, so why do we have to go to trial? So we kind of, just with the mediation, we kept getting good numbers. And then all of a sudden it kind of dried out, and the insurance company, because they look at the records, they probably saw, hey, this firm, they're just going to mediation. They're just taking our money, but they're not actually going to trial. I don't see any jury verdicts. So then things slowed down. So then we had to go back into the courtroom. So ultimately you have to be the trial warrior. That's the way you get the real money. Okay, so let's see. And Burns has a question. Can you do a video on ankle and foot injuries like you did for shoulders? Yeah, absolutely. Let me write it down. Absolutely. I'm going to do it. Yeah, ankle and foot. Okay. Yeah, that's a good topic. I actually was trying to come up with some new ideas for videos. Like today I was working on a case, and I saw this interesting concept. Like I was looking in verdict search, actually. I did a few consults, and I had to do some jury verdict research for a client or a prospective client. And then as I was doing that, I just saw they have like the most recent verdicts. So I thought to myself, what if I just did the most recent verdicts, but kind of did it live? And that way I'm talking about like almost a case analysis of the recent verdicts that came down, let's say last week, or I think they had it up for like they're a little bit behind. So I think right now they have that week of October 25th or something, that week, like the last week in October. So anyway, I was doing that. And then like I would do those verdicts live, and then you guys could ask questions about it if you had any questions, and we could discuss it. That way it's a little bit more interactive. I could maybe do that. Some of the personal injury verdicts. There was one interesting case I saw. I think it was a car crash with a fusion, and it settled during trial for like 1.75 million. But there were a few other cases. There were some defense verdicts in there. I was just looking at the most recent ones from all over the country. Okay. But yeah, ankle and foot, absolutely, I could do. I did the one on artificial disc. I'm going to actually ask the editor when it's going to be ready. It should be ready soon. Okay. And then Leonardo says, I think defendants don't make a motion for summary judgment after the note of issue is filed, because if it's denied at trial or settlement, they can be used against them. No, a motion can't be used against them. A motion is just like when they make a motion for summary judgment, it just basically means that they're saying that, there's no issue for a jury to decide either on liability because they didn't do anything wrong, or on the issue of damages. Like in a car crash, they can file a motion for summary judgment because you don't meet the minimum threshold for serious injury, and they could try to dismiss your case for that reason, right? But no, it can't be used against them. That's not true. So yeah, I mean, they file it sometimes. The reason they don't file it is because they don't think they can win it, and they figure, what's the point? And then the judges maybe get mad. The judges are like, what are you wasting my time with this nonsense, Yeah, so. And then Robbie says, can we do more videos on truck accidents, please? Thank you, Mr. Arkady. You're the best. Yeah, sure, absolutely. I could do some more on truck accidents. I actually was reviewing. I have a few truck accident cases that I'm handling. So I was doing a review. I actually have this manual here. I have it under my desk. I was going to review it, but it's basically the J.J. Keller entry-level driver training. So it's how to obtain a CDL. So it actually is the student manual, and it has some interesting stuff. So I was going to review it and maybe do some videos, because if you look at it, it actually has all the trucking regulations. Like, for example, like control of the truck, basic control, how they have to do pre-trip and post-trip inspections. There's a chapter on shifting and operating transmissions, a chapter on backing. There's a chapter on visual, right? How they have to keep a visual scanning your entire site area. And these are all, rules. This is like the manual. And in addition to that, there's something known as the Federal Motor Carrier Safety Act. And under the Federal Motor Carrier Safety Act, they have specific regulations that you have to follow. And there's the Code of Federal Regulations where it's codified. So if they're violating one of these, then it makes it a much stronger case. So I was going to go through that. There's communication, there's distracted driving, there's space management and speed management. They have to keep their truck under a certain speed or safe speed. There's space, there's night operation, extreme driving, hazards, skid control. There's a lot of different things. Maintenance of the truck. I probably have to maybe do one chapter at a time, do a chapter, and then maybe kind of summarize it or come up with what's interesting to pull out of there for a video, and then do a quick video about it. So yeah, and I'll do more truck verdicts as well, truck verdicts and truck settlements. I've been handling a few truck cases, and I actually pulled up, because I was working on a truck case actually this week, and I pulled up our discovery demands. We have really good discovery demands for trucks because I'm a member of the American Truck Accident Attorneys Group. So we have 94 different, or close to 100, I think it's 94, but 94 things that we ask for, from the driver qualification file to, all these Code of Federal Regulations. So it makes the trucking cases much stronger. Okay, and then Gary says, rotator cuff tear, 2 years of physical therapy. How much is my case worth? It happened in New York. So yeah, with a rotator cuff tear, it definitely could be worth into the six figures, like hundreds of thousands. I'd have to see if there was surgery for the rotator cuff tear. 2 years of physical therapy is pretty serious. I'd want to know what county in New York and how it happened, whether it's a car crash or a slip and fall. But I think, just from the comment, it's hard to say, but better to always, text me, that we could do a full-blown consult. But from the comment, I would say, yeah, it definitely could be worth a few $100,000 at a minimum. And Paul Dottie says, thanks, got it, and thanks for explaining it in detail. Oh, yeah, you're very welcome. I think that's a really good question about that, about going to a jury. And the other question was really good, is how the jury comes up with the number. That's a good question, too. Yeah, absolutely. And the hire says, he says, need more info for Gary Williams, like how did it happen, liability. Yeah, we need to get a little bit more info. And Tommy Cash says, I'm in Georgia and have $40,000 in medical bills. My lawyer said that State Farm insurance adjuster said his highest offer is $20,000. So I'm filing a lawsuit. How long does this take? Yeah, so in Georgia, if there's $40,000 in bills, the lawsuit could take some time. It's hard to say, right? Because you could file the lawsuit and then they could change their position. So right now they're only offering you 20. Once you file a lawsuit, the case goes away from that adjuster and it goes to a litigation adjuster. And if your lawyer is like a real trial lawyer and he's aggressive and he starts doing depositions and shows them, hey, this is worth I have 40 in bills. How can you say you're going to offer me 20? I need my bills paid and my case is worth 200, 300. They're going to say, oh my God, let's just pay him. Or, if they're not going to pay for whatever reason, you're so far apart, you just have to finish discovery, put it on the calendar, get that early trial date. That could, if you're going to go all the way to a jury, I'm not sure what it is in Georgia, but it could take a year or two, right? It could take some time, but it could settle at any point. So as long as the lawyer's a real trial lawyer and he's aggressive, I think they're going to, probably settle with you, which could be much earlier. And then Oseni says, hey, Mr., what happens during the examination before trial? And after that, what happens? Yeah, so the examination before trial is basically the deposition. So that's when the defendant attorney questions you and asks you certain basic information, like what happened, how did the crash happen, how did the fall happen, what's your injury, tell me all the doctors you went to, what are some of the things you were able to do before that you can no longer do, and you just kind of tell your story. But, depending on what the lawyer asks. After the deposition is done, your lawyer then has a chance to do depositions of whoever they want to question, right, from the defendant, depending on what kind of case. If it's a car crash case, just the driver usually of the other car. If it's something more like a premises, you might want to get the maintenance person or the cleaner or the whoever fixed if it's a construction issue, depending on the type of case. And then once all that is done, once all documents have been exchanged and all depositions have been held, then you just put it on the trial calendar, and then you get a trial date. And then, remember, at any point, the case could also settle. So it's kind of like there are a lot of moving parts. So you never know exactly when it's going to resolve. And then Aquatic Shock says, hey, Mr. Arkady, great to see you again, and thank you. How much does a 2-level ACDF recommendation help financially boost your case as to actually having the surgery? Basically, if you have a recommendation for surgery, but you're just not ready to have the surgery. But if you settle the case, you want to make sure there's money for when you are ready to have the surgery. Yeah, exactly. So yeah, it does boost the case tremendously. But what you have to do is you have to, you basically have to explain to them why, right? That you're going to have the surgery, you need the surgery. The doctor says you need the surgery, but you're not having it now for whatever reason. Maybe you don't want to lose your job, or you're scared, or you're going to have it a little later. So then if you're going to have like a full-blown ACDF, which is the anterior cervical, that's the neck, right? The discectomy and fusion, then, medically it's known that you're also going to need it at the level above and the level below adjacent segment disease. So you get an economist, you talk about the fact that just the surgery is pretty expensive. It could be like a $70,000 surgery, but then you're going to need 140 more, right? So 70 plus 140. So you're already over 200,000 just in medical costs, because you're going to need the level above, level below. So, and then you talk about all the physical therapy, all the prescriptions, all the seeing MRIs to make sure that the surgery is done properly. And all the medical costs could be hundreds of thousands. But what about the pain and suffering and the loss of enjoyment of life? That's the major component, right? That's even bigger. So you put all that into it. So it could really increase the value of the case tremendously. I would say, even if you don't have it, but you need it, it could make the case worth into the high hundreds of thousands, even possibly into the millions, as long as it's believable and that you're going to have it eventually. So yeah, I think it really increases the value substantially, but you have to prepare it the right way. And then Robbie says, thank you. Oh, you're very welcome. And Matt says, I'm in the discovery phase in my suit, and the lady pulled out in front of me and then lied to the cops and her insurance. After I got out of the hospital, I went down and got a video. And he's asking, what is the discovery phase? So yeah, the discovery phase is what we just talked about with depositions. So it's basically both, right? It could be you or your lawyer asking for documents. Like, for example, in your case, right? It's a car crash. You'd want to ask for the property damage photos, things like that. You're suing them, right? So they would want to ask you, hey, for your medical records, hospital records, physical therapy records, all that kind of stuff. So that's basically the discovery phase. And he also says, pin in my wrist, dislocated both shoulders, one needs surgery, torn ligaments in my knee. What's my case worth? Oh, that could be worth a lot. I mean, look, dislocated both shoulders and one had surgery, plus with torn ligaments. That could also be I would say hundreds and hundreds of thousands it could get into the millions if it's worked up the right way, depending on how much this lady had in insurance. That's the first question. You got to find that out. And you should already know that if you're in the discovery phase, because usually they have to tell you that by law. So I would just demand that if your lawyer didn't already, and you would get that automatically. And I think he said it's up in Rochester, right? Rochester. So that's a little bit upstate. But yeah, that should be a good case. That should be, definitely it's a very strong case because the injury is so serious. So whenever you have a serious injury, like a life-changing forever injury like that, you're going to command significant money. And Robbie says, truck accidents involving pedestrians. Oh, yeah, of course. Yeah, I could do that too. Truck accidents with pedestrians. Yeah, with pedestrians. Yeah, I can do that. I'll do some videos on that. And Leonardo says, what are the advantages of bringing a watchdog as a witness at trial? Yeah, so the watchdogs, they go with you to your IME. So what you want to do is then bring them at trial. So the defense doctor is going to testify, and he or she might say something like, oh, I spent so much time and I did all these tests and I compared the range of motion to normal and I spent an hour with this patient, And then, the watchdog was there, right? And they're writing everything down. So then you have them testify right after the doctor and say, no, he only spent 2 minutes and he didn't do any range of motion. He just said, can you move your neck? And then the client said, ouch. And he said, normal. And so then it looks like silly. Like, what are they doing? There's this independent watchdog that's just there writing everything that actually happened. And then this doctor is not really independent. He's really, testifying on behalf of the insurance companies. So that's the advantage of having the watchdog. And then Tommy says, thank you very much. You're awesome. I love your videos. It helps a lot. Oh, you're very welcome. Yeah, thank you. Thank you so much for watching. And Aquatic says, basically, I just didn't want to open that can of worms right now. It seems like that surgery should be reserved for a last option, and there's so many other options before that. Would that be a reason? But I'm afraid the case will settle before that. The policy limits are only 100. Oh yeah, I mean, if the policy limits are only 100, yeah, you don't need to do full-blown fusion. I mean, you might need it medically, right? That's up to the doctors, but I mean, you don't need it legally for the case, for sure. You could just settle the case. I mean, you could, even if you just do pain management, like epidural injections or percutaneous procedure, that usually, we've settled those for like 200,000-300,000, even over 500. So if it's only 100,000, you could just settle it for the 100. And Matt says, thank you so much. Oh yeah, you're very welcome. And if you want to text me, you could text me. It's 347-566-9595. Let me drop it in the chat right here. And then we could discuss the case and I could maybe help you with whatever you need. I'm happy to help. And Willie says, if the demand is 10 million, does it settle for half at mediation? Well, I mean, yeah, that would be good, right? 5 million, that's not a bad case, but it doesn't really work like that, right? I mean, it's possible if the case really is worth 5 million, but it just depends, right? Because it could be that your demand is 10 million, but they don't think that it's really worth 10 million. So they might go to trial and then you might get more, you might get 20, right? Or you might get 0. Anything could happen. You can't really look at it like that. But if the demand is 10 million and it's really worth 10 million because they have like the economic damages, they have the lost wages, they have the future medical costs, and they have the developed a human story and a biography, and to explain like, hey, how this really changed my life, and I used to be like this person and now I'm this person and everything's changed, and I have witnesses, I have my neighbors, my coworkers, whoever, from my life, and it's a powerful, very powerful picture that you can paint to a jury, then yeah, I mean, sure, it could be worth 5, it could be worth more than 5. It just depends. And then Mr. Good says, truck accident, hit a bus, 6 people were hurt, but I was the only one that had surgery, $1 million policy. Yeah, that's definitely a great case. Yeah, I'm sorry to hear that. If you had surgery and the truck hit a bus, I mean, there should be enough insurance. They probably have more than $1 million if it's a truck and a bus, if only one was at fault, but there's probably more than $1 million. You have to find out all the excess and umbrella as well. And then Felipe says, hello, I'm Felipe. We spoke today. Oh, yeah. How are you? Yeah, very nice speaking with you. He's a really nice guy. We spoke about his case. Yeah, absolutely. Yeah, feel free to text me again. We could speak again or we could meet up. And then Carve Life says, in a medical malpractice, after medical records are gathered and the certificate of marital, or maybe you mean certificate of merit, is achieved, what is the next step? Are the hospitals or doctors notified, and in what way? Love the channel. Oh, thank you. Yeah, so in a medical malpractice, right, you gather the medical records, you show them to an expert, which is usually a doctor, that's the same specialty as the doctors you're suing. And then that doctor becomes your expert. So if the doctor tells you, yes, I see a mistake here, this is a case of merit, you file a certificate of merit. You usually have to accompany the complaint. So when you file the lawsuit with a certificate of merit, it doesn't have to be signed by the expert. Just the attorney could sign it, but the attorney is swearing. You're saying, I swear under the penalties of perjury that I did consult with a doctor and the doctor told me that the case has merit. And then later, as you're litigating the case, after depositions, when you say, hey, I'm ready to put it on the trial calendar, the defendants can then file a motion for summary judgment and have their own experts say there was no departure from good and accepted standards. Everything was fine. And then you're going to need that expert or another expert to say, no, wait a minute, there is a departure. You did this wrong, and then everything gets itemized and how those departures were a substantial factor in bringing about the injury. And then, those are the two things you need, right? The departure from good and accepted practice, medical practice. The departure is like the mistake, right? You departed from what's good and accepted. But number two, how the departure was a substantial factor in causing the injury. And that's the big place where a lot of medical malpractice cases don't work because, sometimes there's a mistake, but they say, hey, even if I didn't make the mistake, you would still have these issues. So you have to show how the mistake is what caused all your problems. But yeah, and then you're saying the other question was, what's the next step? So basically, if you filed the certificate of merit, you got the medical records, as long as the lawyer thinks there's a case of merit, has the expert, just file the lawsuit. And then when you file the lawsuit, they get served. So the hospital gets served, they're being sued, and then they have to send that lawsuit to their insurance company, and the insurance company appears for them or answers the lawsuit, just the same as in a car crash or any case. And then they're in the case, then you go see the judge and do a preliminary conference and just start discovery. Same thing, right? Depositions and exchange of documents. So very similar to any type of case, really. And then Planet Warrior says, any news on roundup cases and settlements, and what is a settlement date in court? Oh, the roundup cases. Yeah, I have to find out. I haven't been handling those on my own. I've been partnering with some bigger firms that are litigating those. I'm not sure. Some of them may be settling. I know a lot of the mass torts in general settle around now because it's like the end of the year, and a lot of the mass torts have been settling. I know some of the some of the abuse cases were settling, whether it was, I forget which ones, Boy Scouts, or I know there's the church abuse. There's also, there's so many of them. The Roundup, I know Roundup is a big one. There's also, I think, with Zantac. There's a few of them. So I forget now, but I can follow up and let you know. I'll do a little research on that. And then Mighty K says, how long should a case stay in court on the docket? Mine is approaching 3 years, a workplace accident. Yeah, so there's not really a time that it should stay on the docket. I mean, if you can, settle it, settle it in a month, if you can do it, right? Or if you can't because it really needs to be there for 3 years, then okay, then it has to be, but it has to be a good reason because, the lawyer is actually questioning another witness that they need to question. And if they don't question that witness, they're going to lose the case. So it's just if it's a real complicated case, it just depends, right? Every case is a little bit different. Like today I was speaking with somebody and I looked at the file and it just seemed weird to me because there was the case happened many years ago, but there was no activity. It was one court appearance, just a preliminary conference. So, and even that, right? The first conference with the court was 2 or 3 years after they filed the lawsuit, which doesn't make sense, right? Because you file a lawsuit, the other people answer 60 days later. So 90 days later, you should be doing that initial conference, but they're doing it 3 years later. So I was like, what, did they forget about this case or something? So, there's many things that could happen. So you have to be careful. You have to stay on top of it. It's hard for me to say, but 3 years is definitely, a pretty long time already. And then Mario says, do pedestrians who get hit by a car typically have strong cases usually? In 4 years, a long time for a personal injury lawsuit. I was 18 when I was hit. Yeah, I mean, usually I would say pedestrians have strong cases as long as they didn't do anything wrong. You have to look at all the facts and circumstances. If the pedestrian's in the crosswalk, that's kind of like a safety zone. So the driver should have seen them, should have slowed down. Now, if the pedestrian's running across the street in the middle of the street, the driver's just driving and going at speed, say 30, 40, but that's within the speed limit. And the person just runs in front of them. Well, what can they do, right? They're going to get hit. So that's not the driver's fault. So it just depends. But I would say, yeah, usually pedestrians do have good cases. And the cases I've seen and I've handled, I've done really well for pedestrians. And then the other question is 4 years a long time for a personal injury lawsuit? I was 18 when I was hit. I mean, yeah, the same thing like the other person asked, right? 3 years, 4 years. I mean, 4 years could be a long time. For a pedestrian, yeah, it could be long. I don't know why it would take so long. It just depends. I would just get you in for a deposition, depose the car that hit you or the truck, and just, I mean, I'm not really, I'm just trying to think what could be so long for a pedestrian, right? You're walking, there's a car or a truck, the vehicle hits you. I mean, they're going to want to depose you. That's like one day. You're going to want to depose the driver of that truck. That's one day. Maybe you want to do, like, if it's a company, you might want to do like a corporate rep. That's like another day. And then you're done. Like, there's not really, it's not like an antitrust case or some crazy like securities class action. Why would it take years and years? Just put it on the trial calendar and settle it. Or I don't know what the injuries are, but also the way that you approach settlement is critical. It's good to approach it from a position of strength and say, look, pay me my number. If you don't, then it's going to be much more. Then you put them in the corner. And the Machine Marte says, best lawyer in town. Oh, thank you so much. And Mighty K says, if someone I know, attorneys refuse to go to court, refuse to give her any updates, and will not represent her if she won't take a very lowball settlement, what can she do? Oh, I see. So the attorneys are refusing to go to court, refusing to give her updates, and won't represent her unless she. Well, no, you don't have to. You could just she could hire another attorney. I mean, if they're really, giving her such a low number and refusing to go to court, then they're basically, that's known as like abandoning, right? It sounds like the lawyer is abandoning the client, because initially when she hired that lawyer, the lawyer said, I'm going to take your case, or they shook hands, or they had an agreement, right? So the lawyer had that duty to then follow through on the case, take it to court, win the case. Now, if the lawyer thinks like, hey, the case isn't worth anything, the case is worth like whatever, 10 grand, take the 10 grand. But the lawyer can't like hold the case hostage and say, I'm not going to talk to you. I'm not going to go to court. I'm not going to give you any updates, unless you take this 10 grand. Then it's like holding it over her head, right? You can't do that. That's almost like holding them hostage. What the lawyer really has to do ethically is just, if they really don't believe in the case, is they should file a motion to be relieved from the case. Then the judge just, relieves them, says they're not the lawyer on the case anymore, and gives the plaintiff time to find a new lawyer, like 90 days or whatever, for time to find a new lawyer. Or you don't have to do that. Your friend could just go and hire a new lawyer on her own and just fire them, and that's it. And they just have someone else continue the case. But you'd have to look into why they're saying that. And Oseni says, for the insurance disclosure, if the defendant mails the policy limit to my attorney instead of posting it on the court portal, does that mean that the insurance limit is high? So they're mailing the policy limit to your attorney, but not posting it. I'm not sure. I mean, sometimes they do. They don't want to post it, maybe because then everyone would know what the policy limits are. So it could be. I mean, you just ask your attorney. If they're mailing it, then the attorney received it. So just ask them and see, how much it is, depending on the type of vehicle. I don't remember. Was that a truck? Or usually with trucks, it's going to be high, like $1 million or more. So usually. I don't remember the type of case you have, but yeah, I mean, I would just find out what it is. In New York, they have to tell you. You don't even have to ask. They just have to tell you, hey, this is our policy. And then you get all their information automatically. Sometimes they don't. You still have to tell them. You remind them of the CPLR section, but then they comply. And then Chris Colt says, thanks for the lawyer recommendation. Really appreciate your videos. Oh, you're very welcome. Yeah, I'm glad that it was able to help. Absolutely. And the Machine Marte says, I need an excellent spine surgeon. Any recommendations? Yeah, just text me. I know some good doctors here in New York. I could recommend someone. If it's somewhere else, I may be able to put you in touch with some doctors or some lawyers in that, local city. And then they could recommend someone. Because I know a lot of lawyers, like I'm at Trial Lawyers University. There's other groups that I'm in, like all over Trial School. There's a group called Hostage to Hero that's run by a jury consultant. It's an excellent group of trial lawyers. They practice their skills, like their jury selection and other case workshops. There's so many groups. American Truck Accident Attorneys, Traumatic Brain Injury Attorneys. So yeah, with all these groups, I could reach out and see, I could ask the lawyers, hey, do you know any doctors in whatever city? And they could recommend someone. And Mighty K says, thank you. Oh, you're very welcome. King of FM, the best channel. Hi. I had a rear-ended from a big truck, already done 15 physical therapy and 6 PRP injections in the neck. Also, I'm going to do PRP for the shoulder, elbow, and lower back. How much is that worth? Okay, so you got rear-ended by a big truck. So the policy should be at least like what, 750, but probably more, probably like $1 million with umbrella, probably a few million, right? And you've done 15 physical therapy visits and needed 6 was that PRP platelet-rich plasma injections in the neck. I mean, that could be worth a lot already. The fact that you had those injections, that could be worth, a few $100,000, I would say. I don't know what city you're in. It's better to just text me, then we could do a private consult and I could give you more information. But yeah, I think that could be worth a few $100,000 for sure. And then you need more PRP for the shoulder, elbow, and lower back. I'd want to know what your injury is, right? Well, the PRP is a procedure, but why are they doing that procedure? Is it because you have a herniated disc, and that's weird. Somebody's doing so many PRPs. I mean, I've heard of it before, but it sounds like they just did PRP for everything, like the elbow, the shoulder, the knee, the neck, the lower back. I haven't seen that so often. Usually they'll do something like an epidural, then the percutaneous discectomy where they remove they decompress the disc. I know PRP is one procedure that they do, but it sounds like a PRP happy doctor. It's just doing PRPs for everything. I haven't seen that so much. So, I'd have to do a verdict search to tell you what that's worth, but I'm happy to do that. Yeah, just text me and I'll do that for you. Okay, and then Vincent says, have a mediation appointment in December. Policy limit is $500,000. I have a shoulder injury with severe nerve damage. Will I get the maximum pay? So you have a mediation in December, policy is $500, and then a shoulder injury with severe nerve damage. I mean, it could definitely be worth the $500. I mean, it's hard for me to say exactly what will happen, just based on a comment, because I could say, look, if I worked up the case, I think you would get the $500 because I would work it up, right? But remember all those things that you need, like future medicals, the economist, the lost wages. You'd want to have like demonstratives to show like what's the injury, did you have surgery, show the nerve damage, make sure you have like maybe a neurologist or somebody to explain the nerve damage, and then also have your biography and who are your witnesses, like neighbors, friends, loved ones, basically showing what you love to do that you now cannot do, right? The things you love to do and the people that you love, your relationships, family, friends that are important in your life and how that's all changed. So you almost like show two people, the person you were before, who was like a strong person, happy, bright future, active, right? And now the person you are now, more injured, more limited, maybe a little bit more depressed. And why do you have to be that person? It's because of their negligence, right? So you have to make that clear. So yeah, I think you could get the $500 for that if it's built up the right way. Okay, and then Pcash says totaled out a car with a $5 million policy limit available from the at-fault party. Is a 7-figure payout possible? I fractured a lumbar spine and damaged nerves with my 2 and 4-year-old had head knots. Oh, wow. No, I'm sorry to hear that. Yeah, it's definitely possible. Absolutely. I mean, look, if you have a $5 million policy, I think a 7-figure payout is possible. You have a fractured lumbar spine and you have damaged nerves. Now we'd have to see, again, just like the last person, right? We'd have to see what all your medical injuries are, how it's affected your life. But absolutely, it's possible. Like I had a fractured spine, just one vertebrae was fractured and there was no surgery, no injections, just a fractured vertebrae. And somebody was trying to settle the case for like $20,000 and I took it over and I worked it up. And then right before trial, I think we settled it for like $500,000. But yours sounds even more serious because you have the fractured spine and you have this nerve damage. So I'd have to see a little bit more about the injury, but absolutely it's possible. And then Spang says, can you talk about garnishing wages, specifically when the person didn't have insurance and supposedly doesn't have assets? Thanks, I enjoy these lives. Yeah, I mean, when they don't have assets, it's tough, but what you could do is just, you first have to go and just do the case, right, and win the judgment. So let's say you go to trial and you get a judgment, it's $100,000. And then you try to enforce it, but the person doesn't have any insurance, doesn't have any assets. So what you have to do at that point is probably hire like a collections attorney. Just like, if you don't pay a bill and those debt collectors start calling you, And then if you still don't pay, right, what do? They file a lawsuit, and then they try to recover, right? Sometimes whatever it is, right? You have a debt to somebody, credit card, or a doctor, whatever bill, and then they actually file a lawsuit against you, right? And then sometimes they'll get a default judgment, and the judgment will be like whatever, $500 to them. And then what they do is they serve information subpoenas to all the big banks like Bank of America, Chase, to see where you bank, and then they try to get that money. So that's almost like what you need to do, but a lawyer has to do that for you, like a collection attorney. It's tough. It's tough. A lot of lawyers don't take cases unless there is insurance, unfortunately, but it can be done. It's just not that easy. And then the way it would work is if the person makes money, they would garnish, I guess, some part of their wages I guess they couldn't take all of it, right? And the person might lose their, I don't know, they wouldn't be able to eat or lose their home. But I guess there's I'm not sure exactly how that works, but there would be some kind of procedure for that. And J-Rock says, in Arizona, what's the minimum payout for a rear end on the highway? Well, there's no minimum. I mean, you could have cases that go to trial and you lose and get nothing, right? So there's no such thing as a minimum payout. But, if it's a good case, meaning a rear end is good liability. So as long as you have an injury and you could show the injury is caused by the rear end crash, you shouldn't get zero, right? You should get something. And the amount usually depends on how much insurance that car that rear-ended you has. So if they have 100 and you have, let's say, a herniated disc, if it's completely soft tissue, hey, maybe you get paid out, I'm just guessing, but maybe like 30, right, or 20. But if you have surgery, well, now maybe you can get the full 100. So it's really up to the lawyer, the way they build up the case. And then William says, good afternoon. We settled my case. My lawyer has to pay the compensation expenses and put money in the bank for my medical expenses. How long do you think it will take to receive my check? So you settled your case, and the lawyer has to pay compensation expenses and put the money in the bank for medical expenses. I'm not sure what that means, because what do you mean compensation expenses? I'm not sure. I mean, maybe you're talking about liens. Oh, if the lawyer has to pay liens, like, for example, to other doctors, like doctors treated you for free, but now you got to pay them back, right? So the lawyer can't give you the money because he's got to call all these doctors and negotiate. That could take a few weeks. I mean, it shouldn't take too long. So you should be able to get your check fair. The only time it could be delayed significantly is if you have liens with Medicaid or Medicare, because they're just slow to respond. It's the federal government though, so you have to, go through the process. You can't ignore them. That could take some time. That could take even I don't know, sometimes months, 6 months or more. But if it's private doctors, it shouldn't take long at all. And then the Machine Marte says, after 5 years, it's okay to change lawyers. I'm a little concerned about my lawyer after a verdict search. Oh, I see. Yeah. I mean, look, 5 years, that's a long time. I mean, maybe just let them finish it out, but if you're a little bit concerned about them, if you're not happy, you could always try to change, but 5 years is kind of a long time. It's always better to just get a good lawyer at the beginning, that way the lawyer could build everything up the right way. But sometimes I know people do change attorneys. And then Mario, since my car accident after the vehicle versus pedestrian, I have struggled to work or keep a job with fears it'll affect me long term. How do you guys figure out lost future wages? Right. So you just get the economist, and then you talk about the fact that you haven't worked and you've missed time from work. And then there's also something known as loss of earning capacity, like your ability to earn, right? So before, maybe you were able to earn a larger amount because you're able to do a certain job, like a physical job, right? Like a truck driver, let's say. You're able to earn $200,000 a year. But now you can't couple and uncouple those trucks and trailers. You're hurt. So now your earning capacity is down. So you can sue for that. You just have to have doctors talk about the fact that, yes, you can't do it, and then have economists project what the valuations are. But yeah, and then if you have fears, or if you have any then you could see a psychologist or psychiatrist and have that type of testimony as well, because you're entitled to mental anguish, damages. So yeah, there's a lot of different things you can do with these cases. Vincent says, thank you, or you're very welcome. And Roos Dubia says, I was in a motorcycle accident where a guy failed to yield, turning left, and cut me off. I had a fracture at my C7-T1, an artery dissection, and a brain bleed. it was a company truck that hit me. Oh my God, I'm sorry to hear that. That's a horrific case. It's really serious. And I'm going to fully recover, but wondering on how much I could get from a settlement. I have a lawyer now. Well, I mean, look, a case like that, I think you should be able to get the full policy, whatever they have. If it's a truck, if they have, let's say, $1 million with like a $5 million excess, you should be able to get that, because those are horrific injuries. Talking about a fracture from C7 down to T1, artery dissection, brain bleed, and then especially if there's any type of even if it's what they consider, like, I don't like that word, like mild traumatic brain injury, but if there's a brain bleed, there could be some deficits, either like emotional changes, memory loss. That could be worth millions and millions and millions. I mean, that could be worth the full policy. But yeah, feel free to text me. I'm happy to chat with you and go into greater detail. It's just 347-566-9595. Yeah. And then Bagged Boys says, what are the chances of me switching over to you and you handling my case personally? Is that possible to have you as a lawyer? Yeah, I mean, absolutely. I'm handling cases. Absolutely. I mean, just give me the same thing. Just text me. We could chat. And if it makes sense, I'm happy to help. And then SG says, do all personal injury cases go through depositions, or can they settle without depositions? My attorney is saying I might not need to do a deposition. Sounds odd to me. I mean, yeah, some cases do settle without depositions. Usually the smaller cases, like if it's real small, they could settle with you without even doing a deposition, right? Because they're just going to pay like 10 grand or something. The other times are maybe if the case is really clear and it's a really serious case, and then they really think, okay, we have a limited policy. Like say we have 100,000 and you have like a fusion or you have like multiple surgeries. What do we need to do depositions for? Let's just give you the 100 because it's just so clear. But yeah, so I would say, most litigation cases, if it goes into litigation, if you start going to court, they do usually get depositions, especially the cases like where the liability is at issue. Like, for example, a trip and fall, a slip and fall, they'll want to do depositions. A car crash, I think, is more likely not to need a deposition. If it's a limited policy, but a big injury, it might not need one. And here's a question. Doctor recommended posterior cervical laminectomy with a fusion after a rear end by Amazon van. I'm really scared. What's the difference between recommended surgery and undergone the surgery in New York City? Thanks so much for your kindness. Oh, sure. Yeah. I mean, well, the difference is if you're recommended for a surgery, the doctor just says, I think medically you need this, right? But you might say, okay, I need it. I'll do it, later on. Maybe I'll do it in 20 years, but I'm just afraid I don't want to do it now. So then the difference becomes, if you don't do it now and the case settles, you're going to get much less value. But, the fact that you need it increases the value. So let's say you don't do anything and you don't need anything. Your case is worth, you just have like a soft tissue injury, like a herniated disc, right? But no doctor has said you need it. And of course, you're not going to do it because no one even said you need it. So at this point, your case is worth maybe like 10 grand, right? But if the doctor says, hey, you need a fusion for this herniated disc, well, now maybe your case is worth like, I don't know, 200, 300 grand, or maybe, possibly more, depending on all the economics of it, the lost wages, the medical costs, the way the case is built up, right? But then if you end up actually having the surgery, well, now you've actually had it. It's a major surgery. It's life-changing. And of course, you're going to have all the damages from it. So now I think your case is worth maybe like way over $1 million. Right. So it just depends. It's just different tiers. But what I would say is, it's a good idea if you truly need it and you're going to have it at some point, to have it while the case is open, because then you get compensated for it. Because the flip side of it is, look, I mean, you need it. And then you say, okay, I need it, but I'm scared. Let's settle the case. They settle the case for like, whatever, 200,000. And then guess what? 2 years later, you're going to have the surgery anyway, but now no one's going to pay you for it. So you lost like $2 million. It just doesn't make sense, right? So if you're going to have it anyway, you might as well have it. So you really maybe get a second opinion from a doctor and see if you really, really have to. If multiple doctors are saying like, you have to have this, then it's probably means you have to have it. All these doctors can't be wrong, right? So yeah. And Bernard says, I had a cervical lumbar fusion. I was all good. Oh, that's good. Yeah. And Javelin, I just got an L4, L5 fusion today due to retrolisthesis. Besides that, I got an L5, S1 discectomy and a shoulder arthroscopy. And the doctor told me I need a cervical discectomy because my hands might be tingling. Oh yeah, I'm sorry to hear that. That's pretty serious. Yeah, those are really serious injuries. And I hope you get a good recovery. And it's a truck accident with a high policy. Yeah, I mean, also that's a really strong case. If you have a fusion like that, and then you have a discectomy and a shoulder, yeah, that could be like many, many millions of dollars altogether. Absolutely, absolutely. Okay, I have to run, but thank you, everyone. Thank you for being here. Please like and subscribe to our channel. Let us know what questions you have, and we are here for you. Oh, Javelin says, how much do you think it's worth, or a range? I mean, look, based on those injuries, I don't know what city you're in, but based on those injuries, I think it could definitely be worth into the many millions, because you figure a fusion with retrolisthesis, that's serious. L5S1 discectomy is also serious, plus the shoulder. I mean, the shoulder is like probably the least of it, right? So just the shoulder is like 300 to 500, but then you're talking about the discectomy could be into the millions, right? Oh, you're saying a New York City accident happened in Nassau. Yeah, I mean, New York City, yeah, it could be worth like, I'd say 500 plus a million. It could definitely be worth 2-3 million easily. It could be higher than that. It just really depends on how it's all built up, but it definitely has value. But yeah, feel free to text me. That's the best. Then we could just talk about it, and I could give you some advice. I could also look up your case if you have a case in the court system and tell you what I see there, because there's a lot of documents there, like bills of particulars where they list all the injuries. So you could really get a good idea just by looking at it, and it's all free at a public filing. And also, if you wanted me to send you results for the attorney, if you have somebody handling it and you want to know, hey, are these people good? Are they getting, good results? I could send you their, from the court system, from the verdict search, I could send you their verdicts and their settlements, and you could see sometimes it's good, and people say, oh, wow, okay, I'm in good hands. Sometimes, unfortunately, it's not good, right? They have no results, or they have really bad ones like 0, 0, 0, 0. That's not good. So, it just depends. Okay, and then Bernard says, I was all good, then a car accident, the front cervical fusion fracture. I just had post-fusion to fix the fracture, anterior fusion. Oh, I see. Yeah, that's pretty serious. That's serious too. Yeah, feel free to text me. I'm happy to I'll do some consults tomorrow for sure. I'll try to do like 3 or 4 tomorrow. Get everybody in. If there's more, we'll try to do more. And the hire says, thank you. Oh, you're very welcome. And 777 says, what about a diffuse axonal brain injury, white matter, eye impairment, spine and neck bulges and herniated? Oh, wow. Yeah, that's really, that's super serious. I mean, I always think that a brain injury is like the most valuable, the highest type of case. I think a brain injury is worth a lot, because it's a brain injury. It's your brain. It's everything, right? It's your kind of like everything, right? If you hurt your arm, okay, your arm is hurt, but you could still do other things. But your brain is like, it changes who you are. So that's super. I think that's very valuable. That could be the highest value of all cases if it's built up and presented the right way. And Russ Dubia says, thank you. I sent you a message with more details. Oh, thank you. Okay, I'm happy to chat. And Lorenzo says, I have a herniated disc, and just after my second epidural, I was hit again, which affected my treatment. My lawyer is combining both cases, and both drivers had the same insurance. Okay, that's good. Yes, you should be able to get compensated for that. I mean, I'm sorry that happened. And then the machine says, can you provide me with your own verdict search? I'm going all in with you. What C is a very good and honest lawyer? Yeah, sure, absolutely. Just text me. I could send you some of mine. I've discussed some of the cases here, like the one we just did for 2.2, the one we did for 3.5 last summer, and then, but yeah, we have a bunch of verdicts we could share. Okay, all right, everyone. Please like and subscribe to our channel. We are here for you, and we will talk to you very soon. Have a great night. Bye-bye.